Good morning, ladies and gentlemen. Welcome to Osborne Clarke's webinar on the role of HR in disciplinary proceedings. I'm now going to hand over to Danielle Kingdon, partner in our employment team.
Good morning, everyone. Welcome to today's session where we're going to look at HR's role in disciplinary proceedings and how to ensure HR involvement doesn't stray into territory that could give rise to an unfair dismissal claim. I'm Danielle Kingdon, a partner in Osborne Clarke's employment team, and I'm very pleased to be joined today by Emma Ladley, a senior associate in my team. Emma and I are going to talk you through, firstly, the guidance provided by 3 key cases and ACAS on the role HR should take in disciplinary proceedings. Secondly, how draft reports and other communications can lead to problems in disciplinary matters. Thirdly, the red flag scenarios where inappropriate HR involvement may be more likely. And finally, how to get HR role right and avoid any challenges to the fairness of your disciplinary procedure. Today's session is going to take around 25 minutes. Then we'll have 5 minutes to discuss questions, which some of you have kindly submitted already, thank you, and which any of you can post during the webinar by typing questions in the instant messaging window that should be displaying at the side of your screen. When a disciplinary matter arises, one of the first people called will be the relevant HR representative. The involvement of HR in disciplinary investigations is an automatic process and essential to businesses carrying out a fair disciplinary process. It is HR that provides the guidance and support to managers dealing with difficult disciplinary matters, and HR who ensure a consistent, fair application of the disciplinary procedure. HR's experience in disciplinary matters is a valuable resource for employers. Of course, the role taken by HR in disciplinary matters varies from employer to employer, depending on the size and experience of the HR team. In recent years, the spotlight has fallen on the role of HR straying into influencing disciplinary decisions, with the tribunals expressing disapproval of HR influencing the decision-making of those conducting the disciplinary investigation and hearing. A number of important tribunal and court decisions have sought to set clear limitations on the extent to which HR should be involved in the process and to clarify the role that it is acceptable for HR to perform. Looking at these in turn, in the recent case of Dronsfield against University of Reading, the Employment Appeal Tribunal has emphasised that the role of HR is to advise on questions of law, procedure and consistency, and not to stray into advising on culpability or the sanction to apply. Whilst this sounds a straightforward division of responsibility, in practice it is a much more subtle distinction to get right, and the case reads as a cautionary tale against any HR department acting as judge, jury and executioner. In this case, Professor Green at the University of Reading was tasked with the support of an HR representative to investigate the alleged misconduct of Dr. Dronsfield, who was a professor at the university, and who'd failed to report a sexual relationship with a student. Together, Professor Green and an HR representative produced an investigatory report, but significantly here, initial drafts were subject to review by the university's HR department and in-house lawyer. The final version of the report omitted a number of findings that would have been favourable to Dr. Dronsfield, including a passage which concluded that there was no evidence to suggest that Dr. Dronsfield's conduct was of an immoral, scandalous or disgraceful nature. This was important as the university statute provided for dismissal for conduct of an immoral, scandalous or disgraceful nature incompatible with the duties of the office or employment. The Vice-Chancellor appointed a disciplinary panel which, following a hearing, recommended dismissal. Dr. Dronsfield's internal appeal was unsuccessful, as was his employment tribunal claim for unfair dismissal. However, the Employment Appeal Tribunal was troubled as there appeared to be no adequate exploration by the Employment Tribunal as to why Professor Green's original opinion had been deleted. The Employment Appeal Tribunal felt that the tribunal should have asked whether Professor Green had changed his opinion or simply omitted it, and if so, why. The Employment Tribunal should have considered whether it had been reasonable, having regard to the omissions from the final version of the report, for the University to dismiss Dr. Dronsfield. The AT also noted, obiter, that allocating joint responsibility for producing the report to both the investigating officer and an HR representative did not reflect normal practice. This accords with the EAT's finding in the 2015 case of Wrathful against Department of Transport, where the EAT held that HR's advice should be limited to matters of law and procedure as opposed to questions of culpability, which are reserved for the investigating officer. I'm going to take a look at that case now. In Wrathful against Department for Transport, the EAT again found that an employee was unfairly dismissed when the investigation that led to his dismissal had been significantly influenced by HR. The facts, in brief, involved an aviation security compliance inspector employed by the Department for Transport, who spent a significant amount of time on the road as part of his job, for which he was entitled to receive a subsistence allowance. Concerns were raised after investigations into his expenses, and the matter was investigated by the Department for Transport's Head of Land Security Compliance, Mr. Goodchild, who also conducted the disciplinary hearing. As Mr. Goodchild hadn't previously acted in disciplinary proceedings, he first sent the draft report to HR. Although this report was partly critical, it contained a number of favourable findings in relation to Mr. Wrathful. For example, Mr. Goodchild found that Mr. Wrathful's misuse was not deliberate. He found the explanations given by Mr. Wrathful for expenditure on petrol were consistent and plausible, and that he'd made a persuasive argument in relation to his fuel expenditure. As a result, Mr. Goodchild's recommendation was for a finding of misconduct with the sanction of a final warning. There then followed months of communications between HR and Mr. Goodchild, the result of which was a complete change of view on Mr. Goodchild's factual findings and recommendations as to sanction. Over the course of various drafts and suggested amendments by HR, favourable comments were removed and replaced with critical comments, as was the case in the Dronsfield case I mentioned just now. In the end, the overall view of culpability became one of gross negligence, and the recommendation of sanction became summary dismissal for gross misconduct. Mr. Wrathful brought a claim of unfair dismissal that the Employment Tribunal dismissed, but the EAT took a different view. They were worried about the dramatic change in Mr. Goodchild's conclusions after the intervention by HR, which they found disturbing. In their view, HR had clearly involved themselves in issues of culpability, which should have been a matter for Mr. Goodchild. Given the striking nature of the changes, that is, a change from misconduct to gross misconduct and from a final warning to dismissal, an inference of improper influence arose, and the EAT formed the view that HR had been pulling the strings behind the scenes. It is, of course, acceptable for HR to give advice on the way an investigation report is presented and to make sure it addresses all the necessary issues, but when doing so, HR must take care not to advise on what an appropriate sanction should be outside of addressing issues of consistency. The case of Shara against West London Mental Health NHS Trust preceded the Wrathful and Dronsfield cases and established principles that were followed in the two subsequent cases I've discussed. In Shara, the court had to consider a challenge to the lawfulness of a decision to convene a disciplinary hearing to consider charges of potential gross misconduct in relation to alleged breaches of patient confidentiality by Dr. Shara. The report on the charges had been produced by a case investigator, but HR had subsequently altered the report and made the charges more serious. Lord Hodge stated that he would not consider it illegitimate for an employer, bar HR or a similar function, to assist a case investigator in the presentation of a report, for example, to ensure that all necessary matters have been addressed and to achieve clarity. However, the involvement of the HR advisor in this case went beyond clarification. It was held that in these circumstances, an injunction should be granted to restrain the employer from proceeding to a disciplinary hearing. Here the court held that the involvement of the HR advisor, among other things, breached, firstly, an express term of the disciplinary procedure to the effect that the employer would operate its disciplinary procedure in a way that the objective observer would consider reasonable, and secondly, an implied contractual right to fairness. The court also held that the decision to charge Dr. Shara with potential gross misconduct amounted to a breach of contract on the basis that the facts and evidence set out in the investigation report did not support such a charge. As a matter of law, there was no evidence of conduct amounting to a repudiatory breach of contract. Lord Hodge held that the latter issue alone would have justified the granting of an injunction. Therefore, this case effectively established an implied term that the report of an investigating officer for a disciplinary inquiry must be the product of their own investigations. Any subsequent review and alteration by a third party needs to be undertaken with this in mind. The investigating officer needs to be able to explain any changes made following such a review. HR are often under intense internal pressure to deal with particular employees, so it's not difficult to see why they try to manage the process and outcome of a disciplinary investigation. However, as this case showed, in doing so, HR may inadvertently expose the company to an injunction application or unfair dismissal complaint. I'm now going to hand over to Emma, who will take a look at the guidance provided by ACAS on disciplinary investigations and decision-making.
Thanks, Danielle. So the ACAS Code on Conducting Workplace Investigations, which was published in October 2015, doesn't directly reference either the Wrathful or the Shara decisions on the role that HR should take in disciplinary proceedings. But nevertheless, its guidance is still consistent with the judgments in these cases. The Code emphasises that where possible, a different appropriate person should handle each stage of the disciplinary process, and that the usual roles are, firstly, an investigator to gather the facts of the matter, secondly, a decision maker in case the facts warrant further action, such as a disciplinary hearing, and where the option is available, this should usually be a member of staff who is more senior to the investigator, and finally, an appeal hearer, in case an appeal is raised against a disciplinary decision. Where possible, this should be a more senior member of staff to the decision maker, although it's acknowledged that sometimes, in smaller businesses, it may need to be someone at the same level as the decision maker. The Code advises that an investigation report should cover all the facts that were and weren't established, on whether there were any mitigating circumstances that require consideration. It comments that the exclusion of any information may leave an investigation open to accusations of bias and filtering evidence to suit the company's findings. The Code points out that the investigation report should reflect the investigator's own conclusions, and that while an investigator may seek advice from a third party, such as HR, the conclusions should be their own. And this echoes the judgments in Dronsfield, Wrathful and Shara, and is another clear message on the need for transparency in the disciplinary process. The Code acknowledges that it's common for an investigator to be asked to make a recommendation. However, it stresses that an investigator should restrict their recommendations to only suggesting whether any further action may be necessary or beneficial. That is, recommend any formal action, informal action, or no further action. An investigator should not suggest a possible sanction or prejudice what the outcome to a disciplinary hearing will be. Finally, the code emphasises that it should be the decision maker and not the investigator who takes the final decision as to whether or not a disciplinary hearing will be held. This is usually the person or group who would be conducting the disciplinary process. If their decision differs from the investigator's recommendation, then the reasons for this should be written down and included as an addendum to the report. Danielle's now going to talk us through the disciplinary documents which are disclosable in legal proceedings.
Thanks, Emma. Now, in all three of the cases we've looked at, things started to unravel due to changes made to earlier versions of disciplinary reports that could not be explained by the decision maker changing their point of view. Unfortunately for the employers concerned, the earlier versions of the reports were disclosable in the subsequent legal proceedings. So when our internal documents, and particularly draft reports and communications surrounding disciplinary matters, disclosable in legal proceedings, and when are they legally privileged, meaning they can be permissibly withheld during the disclosure exercise? The starting point is that all advice produced and commentary on a disciplinary matter is disclosable at a tribunal unless it's produced by in-house counsel or external lawyers. Earlier drafts of investigatory reports and disciplinary reports will also be disclosable. Basically, employers must disclose all documents in their possession or under their control that are relevant to the matter. This includes documents that support the employee's position or undermine the position of the employer. For this reason, it is essential that any changes to earlier versions of reports can be explained by the person producing the report, particularly where this will have an impact on the ultimate decision reached on culpability and the sanction to be imposed. Now it's back to Emma to run through the red flag scenarios to look out for.
Thanks, Danielle. So there are a couple of scenarios in which HR are more likely to find themselves being drawn into advising on culpability in disciplinary matters. Experienced HR managers may well be tempted to suggest amendments to reports and to pass comment on a case, particularly where they can anticipate problems further down the line or they're aware of broader problems surrounding the individual's employment. The flip side of this is that managers who are inexperienced in handling disciplinary investigations or hearings are more likely to lean on HR for support, as they'll be anxious to get the process and decision-making right. Whilst it's easy, in theory, to appreciate the distinction between advising on law and procedure and advising on culpability and sanctions, it's much harder in practice to avoid straying the wrong side of the tracks when you're dealing with a live disciplinary matter. It's important to stress that HR can have a role in decision-making in disciplinary matters, and HR can make decisions about innocence or guilt in the appropriate sanction. But if they're going to do so, then this needs to be made clear to the employee from the outset and be permissible under your disciplinary policy. The key to ensuring a fair procedure is that the employee facing disciplinary action knows who will be making the decision and has the chance to put their side of the story to that person. This can't happen if HR is influencing the process from the sidelines. In all disciplinary matters, transparency of process and decision-making is therefore essential. The recent Dronsfield and Wrathful cases have raised concerns with HR professionals that their ability to be involved with disciplinary proceedings has been limited. However, the principles established by both cases are not unique to HR and apply equally to anyone seeking to influence disciplinary outcomes when they're not directly responsible for decision-making. To avoid undermining the fairness of your disciplinary process, you should make sure that clear policies are in place, setting out the process for disciplinary investigations and hearings, and crucially, clarity as to who is responsible for disciplinary investigations and who is responsible for making a decision on culpability. That HR's involvement is limited to questions of law and procedure as opposed to matters of culpability, the latter being specifically reserved for the decision maker. That HR can give advice on the way an investigation report is presented to ensure it addresses all necessary issues, and also make sure the investigator and decision maker are aware of previous cases involving other individuals to ensure consistency. That if multiple drafts of an investigation report are produced, any amendments can be fully explained by the investigator. And remember here that draft reports are disclosable in tribunal proceedings unless they can be properly protected by legal privilege. That employees are given the opportunity to make representations to the person who is the decision maker. Any influence from parties whom the employee has not addressed directly would jeopardise the fairness of the disciplinary action taken.
Thanks, Emma. So it's time now to move on to the question and answer session, and we're grateful to all of you who've submitted questions. In the time available, we'll prioritise by looking at the 2 questions with the most relevance to all our listeners. If we don't get to your question now, we'll respond after the session. And please do feel free to contact Emma or me directly. You'll see our contact details on the last slide. Now, our first question is, who is the best person to conduct a disciplinary hearing? Well, I think essentially the meeting should be conducted by a manager who's got sufficient authority to make a disciplinary decision. The person who conducts the disciplinary meeting should be different to the person who carried out the investigation unless this is not practicable. For example, in a very small organisation where there is no one else suitable to conduct the meeting. The meeting can be conducted by the employee's line manager as long as he or she isn't involved in the matters giving rise to the disciplinary process. So, for example, if the allegation against the employee is that he or she behaved abusively towards their line manager, it would of course be appropriate for a different manager to conduct the meeting. And remember, when deciding who should conduct the meeting, an employer should ensure that it applies its own disciplinary procedure. I'll hand over to Emma now, who's going to answer our second question.
Thank you. So our next question is it the investigating officer who decides that there's a case to answer and whether to proceed to a disciplinary hearing, or is it the decision maker who takes this decision? Now, as we've mentioned, the ACAS code acknowledges that the investigating officer might be asked to make a recommendation as to whether informal, formal, or no action is appropriate. But the code also emphasises that an investigator should not suggest a possible sanction or prejudice what the outcome to a disciplinary hearing will be. So I don't think there are any hard and fast rules as to who decides that there's a case to answer, and practices will vary between employers, for example, due to their size and the resources available. But I think it's common for the investigator to decide whether any action is required, and if so, whether that's action of a formal or informal nature, and for the decision maker to then take the matter forward with a fresh pair of eyes and then make the ultimate decision on how to proceed. As we've mentioned, the key to a fair process is to provide transparency and to clearly define the role of each participant in the process. If you do this, then there's less likelihood of a claim of unfair process, bias, or outside influence, which could render a dismissal unfair.
Thanks, Emma. That's the last question we've got time to cover, but if there are others that occur to you, please, as I said, do come back to us and we'll attempt to respond to them in due course. It just remains for me to say thank you from Emma and me to all of you for attending. We hope that you now feel ready to tackle disciplinary processes with confidence and are clear on the parameters of the role that HR should occupy. Thank you very much all.